we'll get started. And again, these webinars are being recorded and will be available for viewing at a later date. The first two webinars are already actually up on our website. So first of all, I'd like to thank all of our presenters for being here today. J.J. Messner from the Fund for Peace will actually introduce the presenters shortly when we get to our panel portion of the webinar. And I will introduce J.J. before he does that. But for now, I just want to first say a couple thank yous beyond our presenters. I'd really like to thank the co-sponsors of this workshop, in particular the International Institute of Humanitarian Law, the International NGO Security and Safety Association, also known as INSA, the University of C Center for International Security and Diplomacy, which is home to Debbie Avon's Private Security Monitor Project, the UN Office on Drugs and Crime, and also thank Chris Kinsey at King's College Defense Studies Department for his support and advice as well. And I'd also like to thank our intern, Mohammed, for running the webinar. He's been doing an excellent job with that. And my co-director, John Richardson, for his help with the workshop webpage. So today's workshop, which is the third in this series of 6 webinars, is going to, the workshop, of course, itself explores requirements and methods for delivering essential training related to the operations of private military and security companies. And as you know, the workshop's purpose is to identify the training that's necessary for the responsible and rights-respecting provision of military and security services. And we want to identify the audience for that training, the methods of delivery, and the means to assess the effectiveness of training. So as I noted, if you want to go back and listen to the first 2 webinars, the introductory one and the one that discusses who needs to be trained, they're up on our website. And all of you who are participating should have received the document summarizing the list that we've compiled to date with regards to who needs to be trained. And we're going to talk about that in a minute because we're going to take about 10 or 15 minutes to collect any additional feedback or reactions to last week's webinar on who needs to be trained. But today's focus, after we do that, will be on what needs to be taught. Of course, you know, as we surmised last week, the who and the what are really closely linked, but we'll try to maintain some focus here to get at the subject matter that needs to be conveyed in various trainings to various stakeholders, and also to talk a little bit about how what needs to be trained is shaped by the operating environment in addition to the who needs to be trained. So I want to take some time here then to just talk a little bit about you know, last week's webinar, see if there's any suggestions, feedbacks, comments. As I said, you should have received, if you participated in last week's webinar, those of you who are new to this probably don't have this, but we have a list that Chris Mayer started compiling, and it's really, it's interesting because, you know, I think the workshop is named, you know, training PMSCs, but really I think what we've discovered is that there's a whole slew of actors that need to be trained beyond the obvious of, you know, PSC and PMSC management and staff. There's the general public in the areas where PSCs operate, military planners and soldiers will operate in the same environment, contracting officers, of course, as well, various state officials that are responsible for regulating and managing the activities of PMSCs. In addition to that, home state government officials who are responsible for authorizing and licensing PSCs. The same would be true for territorial state government officials. People in the local NGO community as well who operate in the same environment. International NGO staff responsible for security management. That would also be true for commercial organizations who have staff who do security management. Chuck Tucker mentioned the board of directors of such NGOs and commercial entities to enable informed decision-making and policy guidance. And then also there was mention made of the commercial and INGO, international NGO umbrella organizations, or excuse me, which develop or promote, sorry, let me back up there, which develop or promote security and management policies and various principles. Donors to NGOs, in particular private sector donors who may specify certain conditions in terms of what they expect in project execution and management to include the use of security. And then local governments we already mentioned, and then Dr. Michael Gambone also made a few additions in our web email burst that we have available to, you know, talk in between the webinars, and he pointed in particular to issues related to local personnel, you know, local nationals, third country nationals who also would need training, and he also mentioned the importance of training translators, local national and third country national employees serving in various staff functions, not just directly in the security provision, and also the importance of training female screeners. And I think what he was getting at there was, you know, really thinking about some of the challenges that may arise in terms of training at that very local level. So I'm going to stop there. I think that's a brief recap of some of the key who's in terms of who needs to be trained. And I'm going to open it up a little bit for any feedback or comments. Presenters, if you want to add something or say something, just feel free to unmute yourself and jump in. Those who are in the audience, again, please raise your hand, and then Mohammed will see that and let me know if you have a comment to add with regards to last week. And I would like to take about 10 minutes to do this. So.
This is Chris Mayer, if I can talk for a second.
Sure.
I think what we've done is we've set it up that everybody needs to be trained. Everybody around PSCs in any way, shape, or form need to be trained. And they will need to be trained on, in many ways, the broad spectrum of things that I have on the list. But not everyone will require the same degree of training. I think we got comments like that from several of the people who have participated in these events in the previous sessions. So as we move forward, there's going to be general subjects that need to be trained, which is what the list that I sent out, that you sent out to everybody for me says. But specifically, we're going to be able to identify what are the specific outcomes within each of those subject areas. And that is what's going to change depending upon the who gets the training.
Yeah, thanks, Chris. And I think it was John McGarrett, if I'm not mistaken, who talked about kind of, your chart is excellent. It's a really good summary of some of the key training provisions and various types of national standards and regulations. And but I think, as John McGarrett said, it's kind of the Chinese menu approach, I think, was the analogy that was used in terms of understanding, linking up the what with the who. Okay, any questions, Mohammed, at this point? None? Okay, well, in that case, all right, then we'll move forward with today's planned panel, if there's no further comments. And I will go ahead and introduce, at this point, J.J. Messner, who's going to be our moderator. And I hope also, J.J., I don't know if I actually said this to you in an email, but I really hope that you'll also take a moment to share some of the great work you've been doing around training, in particular, state security forces using comic books, an excellent comic book, which perhaps may sound odd, but I think it gets at this question we've been talking about, how to train people in certain types of operating environments who may not be very familiar with certain types of human rights, humanitarian law types of provisions. So J.J. Messner is a senior associate at the Fund for Peace and the director of the Fund for Peace's Sustainable Development and Security Program. And in this capacity, he leads Fund for Peace's work on training and implementation of the voluntary principles in security and human rights, another relevant standard directed at the extractive industry's use of security, and manages Fund for Peace's longstanding human rights and business roundtable. He also co-directs the Failed States Index, which I'm sure you're all very familiar with, appearing in Foreign Policy every year. J.J. leads many of Fund for Peace's security and human rights implementation programs, including training programs and site-level assessments in partnership with various international oil and mining companies around the world. And he's also designed and operationalized human rights training programs for military personnel in complex environments. And prior to joining the Fund for Peace from 2006 to 2010, this is how I met J.J. J.J. was director of the International Stability Operations Association, which is, as you of course don't even know, is a nonprofit organization focused on private sector support for operations in conflict and post-conflict environments. So J.J., I'm going to hand it over to you to introduce the panelists. And J.J., if I may suggest, it might make sense to introduce the panelists one by one before they speak instead of rattling off all their bios at once. So starting with Phil Drew, and I want to thank Phil for doubling up here, because the presenter that we had slotted to talk about humanitarian law more broadly was unavailable, and Phil was kind enough to step in and take over that issue as well. So J.J., handing it over to you then to introduce Phil.
Thank you, Rebecca, and it's a pleasure to be here with you all this morning. Actually, looking through the list of names on the attendance list, I'm glad to see a number of friends and very familiar names and people that I haven't spoken with for a long time. So I'm glad that that you're all on the call this morning. Rebecca is absolutely right that I've found myself, and Fund for Peace has found itself in the realm of training, and we've had to take some very innovative approaches, including the authoring of comic books. When I came into this field, I never expected to find myself drawing cartoons, but there we have it. I'm actually going to leave an explanation of that to later in the session, and hopefully by that point, after we've heard from the other speakers, it will be a little bit easier to contextualize. And speaking of the other speakers this morning, we are going to be hearing from 4 experts before breaking into a scenario that's going to be led by Colonel Chris Mayer. Rebecca, I'm absolutely going to take your advice, and I'm going to introduce speakers one by one, but to give everyone a roadmap of where we're going, we're first going to hear from Philip Drew on international standards and rules in the use of force. We're then going to hear from Dr. Ian Ralby on national standards. We're going to then have a discussion on human rights, and that will be led by Dr. Rebecca de Winter-Schmidt, who I'm assuming you're all familiar with. And also then we're going to hear on maritime standards from James Rapp. So first of all, to introduce Philip Drew, he is an adjunct professor at Queen's University Faculty of Law, where he teaches international humanitarian law and international law. He is a Canadian barrister and solicitor who has recently retired after 30 years of military service. And Philip, I'm not sure if it's anything like the Australian system where you get to wear a wig if you're a barrister. I definitely hope so. Prior to his retirement from the military in May 2013, he was Chief Standards Officer at the Canadian Forces Military Law Centre, having completed operational tours as an intelligence officer in the Middle East, Southwest Asia and Rwanda, and also in the Indian Ocean region. A specialist on rules of engagement and training in the use of force, he regularly teaches the subject at several international staff colleges and has instructed at peace support training centres around the globe. Philip, I'm going to hand over to you.
Thank you. I hope that everybody can hear me. And I'll take control of the screen. Again, my name is Philip Drew. I'm delighted to be here today. And good morning, good afternoon, good evening to you all. I'm speaking to you from Canada right now. Today I want to talk about training for private security personnel and more specifically the use of force spectrum. I will say sorry for those of you who had anticipated that you'd see Nils or see and hear from Nils Melcher. Yes, Nils is far more handsome and intelligent than I, but unfortunately he couldn't make it. So I will cover some points on humanitarian law, and I will try to fill his shoes, although they're very large shoes to fill. I'll start with the outline. First I'll talk about some training requirements and goals. Then I will look at the law of armed conflict, some of the essentials and concepts that I believe private security personnel are required to know in order to be able to do the job in virtually any environment where they're dealing in conflict. And then I will get into my area that I am most familiar with and where my specialty lies, and that is the defense of persons and property. Some may call it rules for the use of force. I don't particularly like that term, but I will tell you why in a few minutes, and we'll carry on from there. So,
Phil, I'm sorry, sorry to interrupt, Phil. We can't see your slides. I know you've got slides, so just to give you the heads up.
So what's that?
Yeah, now we see them. Great, perfect. Thank you.
Okay, I will go back very quickly. So my outline is I will talk about the training requirements and goals, LOAC, core concepts, and defense of persons and property. Rebecca, is that better?
Yeah, Phil, we can see your slides, and if you want to lean in a bit closer to the microphone, there was some comments about you're a little bit hard to hear.
Okay, is that better?
Yeah, keep going just as close as you can to the mic. That'd be great. Thanks, Phil.
So I come from this from the perspective of somebody who's been intimately involved in training. I was the chief standards officer at the Canadian Forces Military Law Centre as my last job, and my job there was specifically to design training for the military. And that would be training in rules of engagement, international humanitarian law, use of force, etc. So when we go through the development of the training process, of course, there's a method of doing it. And if you follow the method, generally you will end up with good training. If you do not follow the method, your training is going to be disjunctured and it will probably not meet the requirements that you would like it to. So essentially the first thing we're going to want to do is define learning outcomes and training objectives. I'll probably be speaking to the choir here, but I just want to lay the roadmap. And from learning objectives and learning outcomes and training objectives, we develop training standards that can be used by private security companies in all environments. Now, in order for these to be useful, they have to be readily accessible, they have to be easy to read, and they have to be affordable. So if for example, a standard is put out that is significantly expensive, a lot of people will not have access to it or just don't want to see it because there'll be some free stuff out there. So keeping it as available and accessible as possible is incredibly important. Then creating standard, taking from your training standards, you develop standardized training materials. And in this, you're going to, of course, have LOEC obligations. It's a requirement under law, and guidance on defensive persons and property. And in accordance with both of those, you need training materials that will correspond to the guidance in the documents. From there, you go on and you design standardized training manuals, or excuse me, modules. And the standardized training modules are the type of training that everybody is going to be certified. And I'm assuming that everybody works toward certification of some sort. The training modules all work toward attaining that certification and ensuring that on the way through all the standards are met. And on top of those modules, you create standardized assessment criteria and ultimately certification.
Phil, sorry to interrupt again. Can you make sure that you're speaking as loud as possible into the mic? It's sounding a little quiet.
I will do so. I'll see if I can turn the mic up a little bit.
Yeah, and for those of you who are online listening, I'd also suggest what I did is turn up my volume as far as I could as well. Thanks, Phil.
Okay. I hope that's a little bit better. So we're looking at the fundamentals the law of armed conflict that I think PSCs have to be aware of. We have to take a look at the legal requirement, and that's found in Article 144 of the 4th Geneva Convention. It says that, in part, it says any civilian, military, police, or other authorities who in time of war assume responsibilities in respect of protected persons must possess the text of the convention and be specifically instructed as to its provisions. That's a very, very broad concept, and essentially it's required to be able to deal with civilians, for the most part, who are the protected persons, in times of war and look after their needs and their requirements. One of the big principles is that of medical treatment. What do you do with people when they have been injured, whether you've created the injury or not? There are standards that are required for medical treatment, of course, triage principle, for example, and the requirement to search for and treat all personnel, or persons, protected persons, irrespective of their status. Another is understanding the concept of direct participation. I'll talk to you about that, sexual violence and exploitation of children, and of course the issues as close to many people start to the issue of child soldiers and how to deal with child soldiers. As for direct participation in hostilities, this one is a very important weapon, excuse the vernacular. One of the main problems when we're dealing with PSCs is they do not, in some cases, know what the parameters are and what the limits are for their use of force and what they're allowed to do. And as we all know, private security contractors are not members of the military, and they are not generally peace officers unless they have some type of status that is given to them. Therefore, they are not allowed to engage in attacks. They can use force in self-defense in some cases. However, they are not allowed to engage in attacks. When a person does engage in an attack, it is very heavily likely that they are going to become considered directly participating in hostilities. There are other situations which may put a civilian, such as a PSP, into a situation where they're going to become directly participating in hostilities, such as tactical intelligence collection. And if they become involved in some type of continuous combat function, for example, a drone operator could be considered by some to be a DPH. The problem here is that there is no standardized guidance on what the trigger is for somebody becoming a DPH. We know that if somebody engages in an attack on a convoy, for example, then they are DPHs if the civilian does that. The problem being is many countries have different interpretations as to when that status starts and when it finishes. And the big problem here is understanding who says what in the spectrum. And when a PSC is going into an environment, understanding who the players are and what their interpretations of direct participation in hostilities may be. Even within NATO, there are many, many different interpretations as to what it is. Niels Meltzer is very much a specialist on direct participation in hostilities, and a lot of people don't agree with Niels, and Niels doesn't agree with a lot of people on what essentially DPH means. There are many areas of agreement, however, it's still a trap that an unwary person could fall into if they're not careful, or an unaware person, excuse me, could fall into if they're not careful. So understanding DPH and various interpretations out there are very, very important for PSC to keep itself out of trouble, because the dangers of becoming considered as directly participating in hostilities are many and they're very serious. The first is the loss of protection. So if, for example, an individual is considered to be engaged in a continuous combat function and they are civilian, they lose the protection that they had as civilians. And that means that they are targetable by the military. And that targeting may last for hours, it may last for days, it may last for the duration of a conflict, depending upon what the person, the civilian who is directly participating, has done or is doing. Second critical thing is that they may be considered to have criminal liability. For example, if an individual engages in an attack against a military organization and kills somebody, I think in this case, the Canadian child soldier, Connor, and he was 15 years old, killed an American soldier, and was found to be guilty of murder, and is now serving a sentence here in a Canadian prison. So that is one of the dangers is all of a sudden the PSC is engaged in some type of activity and unaware to that person, all of a sudden are criminally liable for the actions that they've done. And it will depend on the interpretation of the organization or the country that has arrested him for having done what he has done, for example. Another thing that PSCs must always be aware of is something that is so prevalent in virtually any situation of armed conflict, and that is sexual violence and the exploitation of children. Obviously, the first reason is, or first rule must be that PSCs must never engage in that type of activity. I don't even think we need to address that one. However, having said that, they must be aware of and able to identify signs and indicators of sexual violence and exploitation of children in virtually any place. There has been, especially civil war, there will be sexual violence, and sexual violence is an horrific thing, and is, of course, one of the most significant threats to civilians. Any thing that we do, obviously, to prevent it or to stop it from happening is a requirement under Geneva Convention 4 and all of the other conventions that may apply. The biggest problem is understanding that it's occurring continuously around people and what to do once they find out that it is occurring. So essentially, it is no reporting mechanisms. No the level of force, for example, you're allowed to use in order to stop the situation of sexual violence, but no reporting mechanisms, know who to talk to, know when to talk to people about a suspicion you may have or something that you have seen. Same goes for child soldiers. My country considers child soldier to be anybody under the age of 18. I think most countries do now. And I believe that it is more or less customary law now that the age of child soldiers is anything under the age of 18. And you deal with the child soldier after the firefight is done, obviously. However, dealing with the child soldier has its own special requirements. Child soldiers are often exploited by people who are running them. They may have been sexually exploited. They may be drug dependent, alcohol dependent, any level of things, and they must be protected from adults if they are being detained. They must not be detained in the same facility or the same rooms, for example, as an adult, unless, of course, that adult is a parent. Now, moving from the LOAC aspects that I think are important, there is a requirement, this is getting into the use of force mechanisms and the guidance for use of force. And I believe there's a very strong requirement for a handbook that everybody can use. And you'll see on the slide I have crossed out the words rules of engagement, and I've also crossed out the words rules for use of force. For some people, these are simply words, but for me, rules of engagement and rules for use of force have a specific meaning and a specific context. Rules of engagement are used by military forces to define the levels of force they can use, when, and where. Rules for the use of force are also a military tool. In the United States, for example, the rules for the use of force indicate what levels of force personnel may carry out in conducting civil duties. Generally, rules for the use of force are self-defense rules. However, they're still used by militaries. And it's the context in which those are used that bothers me when you try to apply them to private security personnel. There should be no reason for private security personnel to believe that they are military. They are not, and they are not police officers. So I would prefer to have something that we would call guidance for the defense of persons and property, because that is essentially what private security personnel are doing when they are doing any type of security work. Now, I would propose something that is similar in format to the San Remo handbook. For those of you who know me, I am one of the co-authors of the San Remo Rules of Engagement handbook, and we essentially designed that starting in 2006 as a training tool, particularly for use by militaries and staff colleges, etc. But it has become very useful in training militaries across the board, and several have actually taken up that handbook and use it now as a national document. It's been translated into 14 languages. And the nice thing about the manual is that it provides explanations for the fundamental legal principles. And this is what I would recommend for any type of handbook that's going to be used for private security personnel. It also provides guidance on self-defense, defense of others, and property. Self-defense can be a tricky concept in a lot of cases. It's not as straightforward as we like to think, and it needs to be taught. It's not something that comes naturally. There are different procedures, etc., that one needs to follow when engaging in defense of themselves and others. defense of persons and property. And self-defense is obviously the primary one. But there are legal aspects that fall into the concept of self-defense. And one of them is whether or not self-defense is a fundamental right or simply a defense to an assault or murder. In most countries, you can use force up to self-defense, or up to and including deadly force to defend yourself lawfully. But again, in some countries, it's an automatic right. In some countries, you will end up on the stand telling the court why you had to use deadly force in order to defend yourself. In those types of cases, it is a defense to any action. And there may not seem to be much difference between the two, but there certainly is. In some cases, if you can say, I was defending myself, and you can show quite clearly that you're defending yourself, you won't be charged. In other cases, you will be charged, and then you have to defend yourself or your actions from the stand as a witness, as an accused. And that is a situation you don't necessarily want to be in, obviously. And it's very important to know where you are dealing in the world and what the rules are with respect to self-defense in that respect.
Phil, sorry to interrupt again. Can you make sure you're leaning in close to the mic and speaking as loud as possible? Thank you.
Yes. The other aspect is understanding the legal regimes respecting the defense of others who are facing serious bodily harm or death. In a lot of countries, one is permitted to assist another person who is being subjected to serious bodily harm or the threat of death, and to use deadly force in order to protect that person. In some countries, it's permitted. In some countries, it's required. In some countries, only police officers are allowed to do that. Therefore, it's important for anybody who's engaging in this type of activity to know the rules in the country that they are operating. There is no blanket rule in such case, so knowing those things is fundamentally important to anybody who's being sent into these types of situations. There's also a requirement in self-defense to ensure that the force that you're using is necessary and proportionate to the threat. And this, although it may seem intuitive, isn't always intuitive. Understanding what a threat is something that needs to be taught to people. When we are engaging in military operations and preparing for military operations, understanding what a hostile act is or hostile intent might be is incredibly important for personnel who are deployed. They need to know these concepts, and they need to be going through scenario-based training on a regular basis in order to assess a threat and respond correctly. Again, it's something that some people may think is intuitive. It's not. Depending on where you go in the world, the culture of the people that are involved, there are all kinds of differences in what a hostile intent may be. A hostile act is usually quite easy to identify. Somebody shooting at you or hitting you. Somebody pointing a gun at you in a lot of places is considered to be a hostile intent. In some places, it's just what they do. I faced that situation in Rwanda in 1994, where it was not considered hostile intent for somebody to point a gun at you. We had to live with that. We learned how to deal with it. But anywhere else in the world, somebody points a gun at me and I'm a soldier, and they are threatening me. There's a pretty significant chance I would consider that to be a hostile intent. In Rwanda, it was not. And knowing that saved us a lot of very difficult situations. And of course, when we're talking about a necessary and proportional response, we must understand escalation of violence procedures or continuing with the use of force. It is essential for people to understand how to escalate, or to, more importantly, to de-escalate a situation whenever possible. So defense of others. Again, it will vary across the world from country to country. And in some cases it's permitted, in some cases it's required. And in each situation you have to ask yourself, one has to ask himself, what circumstances may I defend others? Under what circumstances may or must I help others? And where and when can I do so? What are the parameters? How much force can I use? What level of force is going to be reasonable in a certain situation? And ultimately as well, who can I protect? Am I allowed to protect the local civilians or just persons that I have been tasked to protect? And the overlying question is always, what level of force can I use? Can I use force at all? Must I just try and get that person out of there and use force as an extreme last resort? Or can I use various levels of force? And when I say using force, I don't necessarily mean shooting people. Using force could be anything from loud hailers to acoustic devices that hurt people's ears, those kinds of things, in order to get a person out of the situation. And the other one is for security personnel, the defense of property. The defense of property is wide open. And it differs from state to state in an incredible manner. In some countries, you are allowed to use as much force as necessary to defend your property. In other countries, you can use minimum force to defend property, and in some countries, you cannot use any force at all to defend property outside of And this is incredibly important when it comes to things such as persons who are aboard ships. Am I allowed to protect the ship, or am I only allowed to protect the persons that are on the ship? It's always a question. And who makes the call in a situation like this? Is it the ship's master, or is it the head of the private security company? Same as on land. You know, if an NGO has hired some private security personnel to help with security in the camp, and the food stocks come under attack, are they allowed to defend that food? If so, how much force can they use? And again, who makes the call? Is it the head? Is it the NGO responsible person on the ground, or is it the PSC person who is in charge of the personnel? These are significant questions that have to be asked. And they have to be answered on a contextual basis as well, because again, it's going to depend on the country you're in and the circumstances that you're facing. Ultimately, all of this adds up to an ability to train people and to train them properly. Starts, as I said, with determining the requirements, and it goes straight up through assessment and certification, and ultimately you hold the person responsible. And accountability comes through training. And I think, for example, developing standardized training mechanisms and standardized book, for example, from which to start that training is essential. So if there are any questions, I think that's it for me right now, Rebecca.
Okay, thanks. JJ, do you want to jump in and introduce Ian?
Absolutely. All right, well, thank you, Philip. Our next presentation is going to be given by Dr. Ian Ralby on national standards. Ian is the Executive Director of IR Consilium. He is an expert on the regulation, governance, and oversight of private security companies and has played a major role for nearly 4 years in various national and international efforts to develop codes, standards, and governance mechanisms for the industry. He has served as an independent consultant on the drafting of the International Code of Conduct, and he helped establish, and for just over a year, ran the Security in Complex Environments Group at ADS, the trade association chosen by the British Foreign and Commonwealth Office to deliver government-monitored regulation of the British private security industry. Dr. Ralby earned a BA in Modern Languages and Linguistics, and an MA in Intercultural Communication at the University of Maryland, Baltimore County, which is just down the road from us here in DC, and a JD at the College of William and Mary, which is also where I went, coincidentally enough, where he was a Jack Kent Cooke graduate scholar. And he also earned a Master's of Philosophy in International Relations and a PhD in Politics and International Studies at St. John's College of the University of Cambridge, where he was a Gates Scholar. Ian, quite frankly, I don't think you have enough degrees. All right, I'm going to hand over to Ian now, and he'll take it away from here.
Well, thanks very much. And now that we've established I'm embarrassingly overeducated, I will try to impart some of what I've learned over the last few years in working in this area. And I think what I'm going to try and do is a little bit different than what Phil has just done, which went really into depth into one specific area, and instead trying to share some experiences gleaned from different encounters I've had with starting to translate the PSC standards into the national context in different parts of the world. I'm going to start off with three points that hopefully will permeate the entire presentation, and apologize in advance if they're a bit glib, but the point is to be a bit catchy. So here they are. Here's what I hope you will take away from what I have to say. First, it's okay to be an idiot as long as you're willing to learn. Second, don't ever expect anyone has any idea what you're talking about. That might be very good for me at the moment. And three, remember the scope, both in terms of breadth and in terms of its limitation. So again, okay to be an idiot if you're willing to learn. Don't expect anyone knows what you're talking about, and remember the scope. So with that, I'll say a few broad points and then start getting into a bit more depth. The PSC standards were developed by people with very disparate disciplinary and geographic backgrounds. They were really the amalgamation of quite a lot of very broad expertise and broad experience. And as a result, they compile different vocabularies, different sort of subject matter areas, and different sort of nuances based on what the people involved in developing them had seen. Now, this is a maturing and ever-changing industry, and so there are always going to have to be sort of reconsiderations in terms of how these standards apply. In the national context, that's extremely important because national context can change very quickly. I'll foreshadow some of what I'll say later on by mentioning Libya. Libya is actually quite near and dear to my heart at the moment, as my brother is out there living, and I have a very close eye to that. And I think it's a terrific example of where one context in which everybody is comfortable and perhaps satisfied and feeling secure can change into a very different context literally overnight. The onset of the conflict, followed by the various events that have occurred over the last couple of years, provide a glimpse into how important it is to ensure that the training on these standards is flexible and is looking not just to the current situation, but to what could be. And so that, I hope, will color also some of the rest of what I say. In that vein, regardless of whether you're dealing with the private security companies themselves, their personnel, the certification bodies, the national accreditation bodies, or the governments that oversee them, or even the public, there really isn't any place for arrogance or complacency in this process. I think it's actually fairly safe to say we are all idiots to some degree with regard to these standards and how they apply. If for no other reason than that they do cover so many different areas, there's no way we could individually be an expert in everything. So one of the difficulties on the national front with that dynamic is that we're talking about some really challenging parts of the world, and sensitivity really needs to be kept in mind. I'm sorry to pause. I think it may be Phil. Could you perhaps mute, because I'm actually getting feedback from you, I think. So you know, to draw that out a bit, I've worked in trying to help translate the standard at the national level in a few countries, and the response has always been very guarded and very defensive regarding you know, trying to impart new wisdom, new knowledge, new ways of doing things. And I think that needs to be, that's of course going to be the case no matter where you go. And I think it's important to keep the sensitivity to the fact that there are lots of livelihoods at stake here. And in many places, this is life or death. So sensitivity is actually quite important. And as odd as that sounds, for a training concept, I think that anyone that goes in with the arrogance of saying they know better than everybody else, they're actually going to come across a very unresponsive audience. So the main aim for everybody, whether you're training, whether you're learning, whether you're a government, whether you're a private security company, or anything in between, is continual improvement. This is a learning process for everybody, and it needs to continue to be so as the standards continue to be implemented ever more deeply and completely, and as the industry continues to change and as the world continues to change, we continue to try to respond to it. So again, it's okay to be an idiot as long as you're willing to learn. So let's look at the standards a little bit. When discussing training, it's very easy to concentrate on the training-specific provisions. And I could go through each of those in depth if we wanted, but I think what might be more useful is to share some of the experiences I've had with some of the parts that you wouldn't think needed training on. And what I have found, regardless of whether I'm just in a different country or even in my own, just talking to people with different backgrounds, is that the same word or expression can mean something totally different to different people. A few examples. Throughout the process of both drafting the International Code of Conduct, drafting the standards, and also implementing them, the term due diligence appears from time to time. And due diligence is a concept that can mean something different to a lawyer, something different to a business person, and certainly something different now to a human rights practitioner. And that is a term that really, in all its contexts, needs to be bottomed out. And so really a simple point, but at the outset of any training, make sure you're being clear as to which of the words and phrases you're using might have dual or triple meaning, and understand that they are going to mean different things to different people. And so you need to clarify the use. Which technical term is it? Is it non-technical or is it technical? So that's an important point. Phil, for example, has just talked to us about the law of armed conflict, and he's used the term LOAC. In the standards and elsewhere, you often see the term international humanitarian law. Now, Phil and I can probably both go through a very technical rendition of why there's a slight difference between those terms. But one of the things that I find very challenging when as a lawyer, actually, talking about international humanitarian law, is that I am often halfway or three-quarters of the way through a conversation before I find out that people actually don't know what body of law I'm talking about. International humanitarian law, to me, means roughly the law of armed conflict or the law of war. To some of the people I've spoken with about this, even in some depth, it has taken me a while to realize that they were thinking about law in a humanitarian context, and that was it. So I'll give you one example of working with a private security company who told me that he had trained all his people in international humanitarian law. I thought that was great, and so I asked him, so do you think international humanitarian law applies to all your operations? He said, well, he got very philosophical and said, yeah, some think that it would, and I wouldn't, but I really think it does. At which point I realized he had no idea what he was talking about, and it was very clear that his context for international humanitarian law was very non-technical, to say the least, and so we were not talking about the same thing at all. Legal interpretation, and I could dwell on this for hours, is throughout the standards an area that really needs some technical expertise in the training. I've seen lots of people wanting to train on international law, international humanitarian law, human rights law, and I'm sometimes terrified by what is said. Some of the basic principles of international law are missed out, and if you don't understand how the international legal framework works, you're off on the wrong foot from the get-go. So the international legal training that is required, and this goes for everyone, because going back to the Libya example, if you think that it isn't important for people to be trained in international humanitarian law at the national level, when this standard is translated at the national level, look to what happened with the guys that were guarding oil infrastructure, domestic, safe, non-violent, non-international armed conflict, non-armed conflict setting, and all of a sudden found themselves in the middle of an armed conflict. And so, you know, they suddenly switched in terms of their legal framework, and if they weren't trained on that, and most of them were not, they would be unaware of what their responsibilities were, but B, potentially setting themselves up for some very unpleasant visits to courts. To get a bit more practical and go more to some of the training requirements that are spelled out, the appropriate use of weapons is one of the areas that has really been interesting to watch. Everyone talks about appropriate use of weapons. I've heard all kinds of people tell me, oh, my people are very well trained. I go outside and I see them, and they're cross-holstering their weapons. They're drawing their guns as if they were swords. And so, you know, the specifics of the content of the training packages really need some expertise, and not just from somebody who has done this within a company. There's sometimes some outside expertise is necessary. Taking weapons home is another great one. You know, there's a requirement that says that I think all ammunition and weapons have to be accounted for. And I've seen lists of just the people that have all the weapons and ammunition, and that's it. So, you know, very, very uncertain as to who's using them in what way and when. So let's look at as well at a few of the things that aren't actually listed as training. Vetting. Vetting is in an area where there's actually a vast degree of difference in terms of what's meant. Part of it is not just to go through a process, but also to not be fooled into relying on non-functional systems. I mean, understanding this, the standard is about substance, not just a tick in the box, is extremely important. I worked in one country where everybody told me they vetted their personnel using the criminal backgrounds check of the police. Next sentence, of course, the criminal background check of the police is completely inaccurate. And everybody knew that, but nevertheless, as far as they were concerned, their vetting requirements were met by having ticked in the box, by having gotten the CRB. And, you know, they were all, you know, aware that maybe the person that they were employing had actually been to jail just a year prior for something, but it just wasn't, for whatever reason, showing up on their criminal background. Finally, one last example of meaning that gets very technical and confusing, business continuity. Amusingly, I've heard quite a few people say that that means that you need to be in continual operation as a business. Well, not quite. Obviously, there's a technical meaning to it that requires that the company have looked for ways to maintain operation as a business in the event of undesired consequence events. So, you know, if a storm comes through and damages some of your infrastructure, can you continue to operate? If, you know, your armored vehicle has a car accident, does that mean that you stop being able to operate a cash transit profession? So don't ever expect anyone has any idea what you're talking about, is the sort of glib summary of that. Finally, the scope. Remember the scope. The scope of the standards when applied in the national context is a little tricky. Some states have, well, states do have some flexibility as to how to set the scope, and some have already looked at sort of limiting it or broadening it depending on their national interests. But a few key points. It is very broad in the content, as we've said, across lots of different disciplines. One person can't audit it alone. Equally, one person can't be implementing it within a company alone if they aren't willing to bring in some advice and assistance from expertise across the different areas, including law, including human rights, including environmental, including operational. So there's quite a lot of different things that need to be brought. And it's not just knowing a little bit about each of these areas. It's not a Wikipedia understanding. It's actually having the discretion to understand how these different areas apply in the particular context of the business and in the private security arena. Second, it's not, however, unlimited in its reach. There's a real problem that I think is already starting to arise with some of the certification processes, where two different certification bodies are working with the exact same standard in the same country and certifying to different things, or at least purporting to certify to different things. So there needs to be some oversight on this front in order to make sure that one company isn't being unduly either prejudiced or benefited by an anomaly in the certification process that says one person's one operation is now certified to operate throughout the world and the other one's only operating in a county. So there is some oversight and training and awareness that's needed for accreditation bodies as well as certification bodies on that front. And then the last sort of broad point I'm going to make is that, and I've said this publicly before, but this is an important thing to recall. The comment is, I can't believe I got bit by that dog. I was wearing bug spray. And I think there needs to be some realism about what the standards are, what they can do, and what they can't do. Bug spray might protect you fine against bugs, but it isn't going to get you from a dog bite. And equally, the standards aren't going to be the complete antidote to all problems that the private security industry has, is, and will face. So I think realism is extremely important. So remember the scope, both in breadth and limitation. So last couple of comments, I thought I'd put out one thing for each of the different, a number of the different people we've said need to be trained, and this is for the national standards. So the first one is clients, and it's very simple. They need to be aware that the standards exist and that it's in their interests to require them. Governments, they need to be aware, and this sounds weird, but they need to be aware across their different departments, both that the standards exist, but also that they have standards bodies. Quite a lot of countries will try to go out regulating their private security industry and develop standards for them without having first checked, because their department just didn't coordinate, to find out that they actually have a national standards body that could adopt the PSC standards or others and actually oversee it with some adult supervision. This isn't a process of reinventing the wheel. Accreditation bodies, they need to be aware that these standards are a bit different. The human rights element is different and the complexity of them is different. So they can't just expect the certification bodies to operate as they would on another standard. Certification bodies likewise need to understand that no one individual really can do the full audit because of the discretion that's needed and discernment that's needed at the expert level. Private security companies, they need to recognize, and this is a tough one to swallow, but it's really important, that they may be onerous and expensive. I.e., getting certified to these standards is not easy, and it does cost money. But if they do it right, going through the process should make them both a better business and more able to make money, both in terms of the efficiency within the organization that's created, and in terms of the ability to reach to clients of a higher caliber. Private security personnel, I think it's very simple. If they want to be in the industry, no matter what their background is, they can be the most elite former military fighter, they are going to have to learn some new things. The context is different and the requirements are different, so they're going to have to be willing to learn. And finally, the public. The private security companies are not above the law, but also not above other means of accountability. The law is not the only mechanism for accountability, and so they should be aware that they can bring grievances to the company, to the certification body, to the accreditation body, and both legal and non-legal interests are now at play. So I think that's really important. So just in conclusion, this is a long, difficult, and ongoing process, but it's a learning process. The biggest danger in the training process is assuming understanding and assuming or being arrogant about your own knowledge. I think we all need to be continually working to improve, get deeper into the standards, and really just continue to keep our eye on ongoing maturation of the industry, professionalization of the industry, and improvement of the standards of the industry, so that there is genuine accountability ever more, and that we're all becoming more expert at how to deal with this. So that's all I have to say for now.
Well, thank you, Ian, and that was fascinating. And I got to say that it's okay to be an idiot as long as you're willing to learn, and don't expect anyone to know what you're talking about. Has made me feel a whole lot better about myself. We're now going to move on to human rights, and we're going to hear from Dr. Rebecca de Winter-Schmidt. I'm thinking that Rebecca really doesn't need me to introduce her, but I'm going to do it anyway. She's co-director of the Initiative for Human Rights in Business at the Center for Human Rights and Humanitarian Law at American University's Washington College of Law. She is an expert in business and human rights, in particular pertaining to the private military and security industry. She's a member of Amnesty International USA's Business and Human Rights Group, and she chairs the Working Group on Private Military and Security Companies. Until 2012, Dr. de Winter-Schmidt was an assistant professor at American University's School of International Services Peace and Conflict Resolution Program. She received her PhD from American University's School of International Service for her dissertation, Business as Usual, the Mobilization of the Anti-Sweatshop Movement and the Social Construction of Corporate Identity. She received her master's degree from the University of Marburg, Germany, and her undergraduate degree from Dickinson College in Carlisle, Pennsylvania. And just before I hand over to you, Rebecca, I am just going to remind everyone that if you're not a speaker, if you could please put yourself on mute. The wonders of modern technology mean that microphones are very, very sensitive and we can hear everything. And I'm going to leave it at that. Handing over to you, Rebecca.
Thanks, JJ. Thanks so much for that introduction. So I am going to do my best to stick to the 5 to 10 minute allotted time because I want to make sure we have time to discuss the really interesting presentations that we've heard this far. And as JJ said, I am going to be discussing human rights, and I'm going to do things from a slightly different approach. Once I figure out how to advance my slides. Why is that not working? I am going to not so much tell you what human rights exactly you are supposed to train, one of those many who's that we've identified on, but I want to rather take an example of private security companies and think about what kind of process one has to go through when deciding what needs to be trained. So, and one way to get at that is to ask, what's the purpose of human rights training? And besides they made me do it because of the standard. And I think that really depends on your perspective. So starting off, as I said, with private security companies themselves, there's the very perhaps obvious business case, right? And I'm not going to go into too much detail here because I hope it's relatively self-explanatory. It's the idea that it helps to mitigate risks associated with serious incidents, both risks to your brand and legal risks in terms of legal liabilities that may arise. As Ian mentioned, it's about ensuring the effective delivery of quality services. Human rights trainings contribute to improving but also demonstrating compliance with various types of regulatory requirements, be they voluntary or mandatory. And they're also important in terms of, thinking about how human rights commitments can filter down through the supply chain, because, a lot of the standards also require that suppliers also demonstrate similar adherence to the various requirements embedded in different standards, including on human rights training. It creates a brand reputation, I think, that Ian touched on this, that helps attract good clients. And I would add also it creates a corporate culture that allows you to attract and maintain good talent. Also, it's important from an entire industry perspective because the actions of a few quote-unquote bad apples can really affect perception of other companies that are in the industry. But I think it's also important to remember that, even if you're demonstrating, legal compliance, demonstrating adherence to standards, if you're proving yourself to be a profitable company, that's not enough. You have to think about the fact that you have to maintain what's called a social license to operate. And that basically means that, you can check the boxes for a certification, you can, legally be adhering to everything that's required of you, but if society perceives you as being an illegitimate or poorly performing company that's engaging in misconduct, you're going to have a problem. So I guess, yes, we all like the business case is basically about the idea of doing well by doing good, and yes, that's the case. But I think it's also important to remember that the bottom line isn't and can't be the sole driver, and that even when there's instances when it's less expensive not to respect human rights, obviously you still have to, and I think that's a given. And, again, in terms of purposes of the training, it really depends on the lens that you're viewing it through. If there's different stakeholders, different who's that we've gotten at, and they'll have all their own kind of reasons or justifications for understanding why human rights trainings are important. So state clients, for example, obviously states are obligated under international law to protect human rights, including from violations by economic actors. States themselves face potential liability if companies are acting on their behalf engage in misconduct. The conduct of companies can impact the state's various, policy and strategic objectives, responsibilities in terms of, fostering harmony, democracy, stability, and protecting minority and marginalized populations. Similarly, from the perspective of private clients, be they for-profit or not-for-profit, the conduct of private security companies is going to affect their reputation, their potential liabilities, and affect their ability to attain their business objectives or fulfill their missions. And we can go through all of these who's, which have been identified, and will have their own reason for understanding what human rights trainings are for and why they're important, which will shape, of course, what the content is going to be. But I think that whatever the justification, whatever the lens through which the need for human rights trainings is looked at, human rights are non. They're fundamental. They're fundamental to all of us because all of us really, and it's in terms not of just being for a company. It's fundamental in terms of how companies understand how they manage their businesses and deliver their, So I just want to emphasize that point. So again, why is it so important to define the importance of trainings? It helps us understand who has interests in ensuring respect for human rights and why. It helps to determine who needs to be trained on what, and it allows for effective uptake and learning because the fact is you can teach someone human rights but they don't understand why they have a need to learn this. They're not going to remember what you've taught them. And I know that from years of teaching undergrads. So what should be taught? I'm just going to take one of the who's, the private security companies, and of course it's going to be a little bit different if we're talking about what personnel versus management need to be trained on. But one place to start in terms of thinking about what should be taught, is the standards, right? And Ian's gone over some of this in terms of the International Code of Conduct, ICOC, and then the ANSI ACIS PSC1 management system standard. They're both just laden with references to human rights. I counted once for the ANSI ACIS standard. I think this is like around 137 or something like that. So it's really, you need to kind of parse apart what, in terms of those human rights references, are relevant in terms for management to learn about, and in terms of what personnel need to learn about, and beyond the general commitments that exist, kind of upfront, kind of preambular language for both the standards in terms of companies need to ensure that they and their personnel will apply, adhere to applicable human rights law. There's also a lot of very specific references to human rights, be it the kind of what I like to call the prohibitions, don't do this. To, as Ian touched on, to the kind of things that management needs to think about in terms of how they're doing their business and the impact of human rights, right? So, for example, the ICOC has a specific commitment regarding, commitments regarding management and governance to include the importance of creating safe and healthful work environments, which are obviously labor rights issues, or, in terms of developing a company-level grievance mechanism, which is about, ensuring that there's some accountability for respecting rights and when that doesn't happen. We already talked about vetting for past conduct. That would include also not just looking at criminal records, but also as far as possible trying to get at any other instances of potential past involvement in human rights abuses. So and the anti-ACES PSC standard, that really, the bottom line I would say in that standard is that really human rights factor in some fashion to all phases of that plan, do, check, act model, which is at the heart of any quality assurance management system. And I can't, the standard's lengthy, and I can't get into details in terms of how human rights factor in each stage of that plan, do, check, act model, but just a few examples, in terms of the planning. Companies, when they're conducting a risk assessment, which is one component of doing human rights due diligence, it needs to consider their ability to ensure that they're actually abiding by human rights principles that are embedded in codes and in the standards. In terms of operation implementation, here's where training comes into play, right? Again, what to be trained on. And just generally, the standards, it talks about the fact that there need to be procedures in place to ensure that all persons with which the security provider, the company comes in contact, is treated with dignity and respect, and needs to create systems for reporting nonconformance. And I can go on, but again, the idea is that this is not, human rights training is not an add-on. Human rights need to factor into every phase of how a company does its business. And in particular for the anti-ACES standard, there's fairly elaborate. It's fairly specific in terms of what needs to be done in terms of training, in particular in the guidance that's attached to it. And it goes into particular human rights that need to be respected, certain non-derogable human rights. Those are ones, non-derogable simply means that they're rights that are respected no matter what type of situation we're talking about, be it a state of emergency, be it an armed conflict, war, what have you. The guidance also goes into the kind of content that needs to be in a code of ethical conduct for personnel, including all those, as I said, what I call the prohibitions. And it's very specific on training in terms of not only content, but timing, something we discussed last week, prior to deployment on an ongoing basis, who, the personnel, internal and external stakeholders potentially affected by what are called undesirable disruptive events in the standard, subcontractors and so on, and also how to create training. There's some guidance there. Determining the skills that are needed to perform various competencies within the quality assurance management system, assessing the gap between individual personal competencies and needed competencies to make sure the management system is being implemented well. Selecting suitable methods of delivery, evaluating, improving. So these are all things that we're going to be touching on throughout stages of this webinar, but they're also things that companies need to think about when developing trainings that help them ultimately implement the management system standard that's at the heart of the PSC1. Now, so I said that standards are a place to start looking to and determining what needs to be taught. But standards are really only a starting point, right? The ICOC, there's principles that's within the ICOC. The anti-ACES PSC1 is, it's a management system standard that with elaborate guidance, but it's also, and it helps to figure out how to meet the principles of implementing standards. But the PSC1 needs to be tailored to companies, and that's what management system standards are, right? They don't tell you exactly what to do. They tell you a process for doing something. You need to figure out how you do it in a way that makes sense for your company and where you operate and the kind of services you provide. And this is also true then for any human rights training. It needs to be tailored to what your needs are. So it's not a check-the-box exercise, right? You can't pull out, excuse me, the Universal Declaration of Human Rights and say, oh, that's right, let's look at some of those prohibitions. So yeah, check. I taught my people on Article 3. They know that people have a right to life, liberty, and security, and check. I taught them about Article 4. Slavery and servitude are bad things. They shouldn't be doing that. Same with torture and their cruel, inhuman, and degrading treatment. That's not a human rights training. And why is this the case? Because human rights themselves are principles. There's a high level of abstraction. If you look at the UDHR, if you look at what's we talk about the International Bill of Rights, which is the Universal Declaration of Human Rights, and two key covenants: the Covenant on Civil and Political Rights, and the Covenant on Economic, Social, and Cultural Rights. And the UDHR itself has 30 articles. The two covenants go into particular subsets of rights: civil rights and political rights, and then economic, social, and cultural. And they themselves are also very lengthy documents. And of course, within the UN human rights system, there's a whole slew of very specific treaties and conventions that speak to particular topics: the rights of women, the rights of immigrants, what have you. So, you can't just look at these documents or even just tell people to read them and think that that's somehow a human rights training. So that's challenging them. So what human rights are we then supposed to teach people? And well, the problem is, and this is something I think John Ruggie realized, he's a special rapporteur on business and human rights, is that if you look at his two key documents, the framework, the Respect, Protect, and Remedy framework, and the guiding principles in business and human rights, nowhere in there is a list of what human rights companies must respect. Why? Well, because frankly, companies can potentially impact on any right depending on where they're operating, the situation they find themselves in. So I know that's no solace, so because you still need to figure out what the heck you're supposed to be teaching. So, so I think one place, in addition to the obvious of looking at the standards and figuring out what they say, is also to think about doing a human rights risk analysis. You need to know the prevalent rights issues in the operating environment you're in. Now, of course, and this is something I think that Phil addressed really well in terms of you can teach the rules of use of force, but you're going to come up with specific situations where you're going to be challenged with figuring out how those rules apply. Or, I'm sorry, Phil, you didn't use the term rules of use of force. You talked about the principles for defending people and property abuse. I got that right. But in any case, but again, it's about the application, which is going to be very context specific, and that's same for human rights. You need to figure out what are the pressing human rights issues in the environment you're in. That being said, here's some solace. Of course, there are some human rights risks that are fairly consistent across the private security industry, and Phil touched on some of those, right? Issues relating to use of force, issues relating to sexual violence and exploitation, and that sort of thing. So there's going to be a good portion of any training that you're going to create that's going to be very standardized in terms of what you're covering in human rights. But as I said, excuse me, you need to know how you can potentially impact on a particular human rights climate. You need to identify which risks can be mitigated and which, frankly, are going to have to be accepted to some extent. And not only do you have to identify those things, but that also needs to be communicated. And this is very important both internally and externally, and that's something that's very clearly discussed within the PSC 1 standard, the importance of this risk communication, not just identifying and doing your own risk analysis, but communicating it outwardly. You need to understand how training will help mitigate risks, and this segues then into some of the how to train. You can't, as I said, you can't train on principles, and you translate principles into an understanding of how to respond and what possible courses of action are in light of a particular scenario in a specific context. So that's what you really need to get your people to that point. Not being able to recite key articles in the Universal Declaration of Human Rights, but rather understand what those principles mean in practice in a particular situation that you're confronted with. And frankly, those situations aren't always going to be easy. There may not always be a very clear-cut answer, but at least you need to have people understanding how their behavior is driven by certain underlying principles. And you need to make human rights real, frankly, and this can be very challenging, and we're going to get to this, I'm sure, when we get more next week to the how, the methods, the pedagogy behind training. It's going to be very challenging for certain trainees, in particular, I'm thinking in local operating environments, who, frankly, human rights, have a framework of reference. Human rights doesn't mean so much, and that's not just something, frankly, that's the case in certain types of regions. I think we tend to think of this as being the case in the developing world. My students have often come from very diverse backgrounds, and frankly, I'm surprised because I tend to expect that my students from the U.S. or Europe or elsewhere are more inherent somehow understanding of human rights, and actually I find it's often the opposite. A lot of my students who are coming from other parts of the world that we may not associate with being traditionally from the areas where human rights have risen, out of the Enlightenment originally, they're actually very much aware of what rights are, and they even get it at a more intuitive level. So don't assume, getting back to Ian's important point, don't assume. But basically, I think the bottom line here is, checking the box in terms of meeting what the standards say will get you technical compliance. But that's not going to be enough in terms of identifying, adequately mitigating, and addressing risks. And it's not also going to necessarily get you to the point where you're able to really ensure respect of human dignity when you interact with different people in the course of your operations. But again, I want to get back to something else that Ian said. Excuse me, don't reinvent the wheel. Tap into outside expertise. Be it human rights academics, practitioners, there's human rights educators who really know how to convey human rights in a very concrete, tangible, real way. Tap into specialists in cross-cultural communication, especially when you're teaching human rights in an area where as I said, that framework may not be largely known or thought to be valuable. And have a human rights lawyer review your trainings, especially getting back to the whole compliance issue. Make sure that what you're training is linking back and helping to help you meet what's in various standards or regulations. So I'm going to stop there. I hope I stuck to my commitment not to be too long. I'm seeing probably not so much. Thank you, and JJ, I'll give it back to you.
Thank you, Rebecca. We now move on to our final presentation for this particular segment, and that will be a presentation on maritime standards by James Rapp. James is managing partner for 3RG Security, which is a company that provides security and risk management services and a range of training services, including counter-piracy training for team leaders and security operatives. He is also a member of the executive committee of the UK's Security in Complex Environments Group, the SCEG, and it was through this that he coordinated work within SCEG to achieve an accredited qualification for maritime security operatives. This is now in place with the highly respected vocational education organisation City and Guilds. He is also Britain's member on the ISO working group for ISO PAS 28007 for private maritime security companies. And with that, James, I'm going to hand over to you.
Thanks very much indeed, and good morning, good afternoon to everybody. I hope I'm going to just bring in now some of the areas where training in the maritime domain is rather different to the land domain. And in particular, I think I'm going to stress the significant importance of the operatives and the companies operating the maritime space understanding the legal and regulatory context for the contracted services they're undertaking. The maritime industry, just as background, it's probably one of the most regulated industries in the world, and largely driven by safety environmental issues. But when maritime security came along in a much bigger way than in the past, our clients weren't sort of surprised by the fact that there was a need for more regulation, and they, by and large, are in a good position to embrace it and will want to do so. Just move on one. Oh, hold on. Sorry about that. My screen is not moving. Have I got the screen, Rebecca, or have you got it?
You have it, but for some reason I had the same issue. It takes a moment for some reason, I don't know why, to start being able to go through your slides. Just give it a second, see if you can advance now.
Okay. There we go. Right. Firstly, I want to talk about the legal context, therefore, for maritime PSCs. And as I said, it's one that our clients will be clear of and ready for. The major instrument and the most significant part of the law is that established by UNCLOS, the United Nations Convention on the Law of the Sea. But the regulations that operate also include other conventions, resolutions and agreements, and it's very important for us to understand the relationship between the overarching law of the sea and where the jurisdiction of the flag state comes in. UNCLOS, not ratified by the USA as we know, but generally regarded as having the force of customary international law. This is the law that states, well, gives the key provisions of what the coastal state has in terms of sovereignty and jurisdiction, and that is within the territorial sea, except in the case of ships undertaking innocent passage, and then what provisions there are for the flag state, and the flag state has exclusive jurisdiction on the high seas over the ships that fly their flag for everything from administration, technical and social matters. And this includes the manning of the ships, the training of the ships, and indeed the activities of other people on board, such as armed guards. Now, if there's an incident on the high seas involving a privately contracted armed security person or armed security personnel, then the jurisdiction lies in the first instance with the flag state. But if the incident happens in territorial waters, then the jurisdiction will tend to be exercised by the coastal state. So it's very important in the maritime sphere to be conscious of where you're operating and what law applies. or what jurisdiction applies. Another aspect of UNCLOS will concern the standing of the armed team on board and whether they have any immunity from prosecution. The scenario we've got set up for this webinar, we've got the multinational task force being supplied by ships flagged by their home country, normally having an armed security detachment on board, but the scenario has stated that they're from the nation's armed forces. Well, in this case, they're sometimes known as vessel protection detachments, and arguably they're acting as agents of the flag state. UNCLOS does state what the standing of a warship is. In Article 95, warships on the high seas have complete immunity from the jurisdiction of any state other than the flag state. So that's for the warship. Is a military detachment of armed security personnel, the way we've got described in the scenario, the same? Well, the debate continues. There isn't much case law, but as we know, there is a case going on in the Indian courts, and has been for a while, with Italian Marines who are, I think, charged with murder of the Indian fishermen. Do they have immunity, which Italy will be arguing, or do they not? But what thing is for sure is clear, and that is that privately contracted armed security personnel, be they ex-military or ex-police or whatever, they don't have such immunity. But exactly what will happen if we're in a law case, what will happen, well, that isn't quite clear either, because there's no case law yet to establish how it will go forward. But as well as UNCLOS, as I put in my slide there, there are other international conventions that the private security company has got to take on board, such as SOLAS, the Safety of Life at Sea, and the International Convention on the Standards of Training, Certification and Watchkeeping, STCW for short. But there are others, and the PMSC, I say PMSC, I'm sorry if people are confused with that, but in the IMO they always talk about that, private maritime security companies, or maritime private security companies, they've got to understand how all these conventions and regulations apply to their personnel. And then below these particular overarching statements of jurisdiction and law, we've got, in the case of the whole recent extension and expansion of piracy, we've got the Maritime Safety Committee of the IMO, who have, some say slightly reluctantly, but have had to do it, moved into giving instructions or guidance, at least, in terms of what member states should be looking at doing to combat piracy when armed guards are being used. And as those of you who are familiar with the maritime space won't need me to tell you the numbers, but there have been 3 or 4 important circulars put out by the IMO, one for ship owners, giving them interim guidance on the use of armed guards, one for flag states, and then one by the IMO for private security companies operating the maritime space specifically. The most unusual route, really, for them to write a circular for non-shipping community people, but security companies. But that circular 1443 is the one that led to the IMO asking ISO to write a standard, which became ISO 28007. A brief mention on Montreux and the ICOC. As most will know better than me, Montreux places obligations on states in situations of armed conflict. So the IMO have understandably restated in their circulars that it's not relevant to piracy and armed robbery at sea. Similarly, the ICOC, whilst containing a huge number of principles that are very relevant to armed guards and private security companies operating at sea, the ICOC have stated in these circulars that the IMO has stated the ICOC is not directly applicable to deploying of armed guards on board merchant ships. However, there are many important principles contained in the ICOC, and because of that, training companies and private security companies most definitely do inform and train their operatives on the main principles, A, because they're important for what we're doing, but secondly, because as signatories, as almost all of them are to the ICAC, then they're obliged to do so. Moving on now to training itself, having covered the legal context, which does set the whole tone for how the security companies operate at sea and how the team leaders and the operatives have to understand what they do. Training really comes in two or three elements, depending how you want to split it. I like to think of it as that needs to be delivered to individuals as generic training, how to be an armed guard and understanding the rules and regulations that apply while you're doing that job. This is intended to prepare the individual for his role of protecting his ship, and all he has to do to apply graduated response if he needs to a potential attack, how he applies the rules of force, rules for use of force properly, and I will use that term, but I understand what Philip was saying earlier in terms of language, and how he applies that, all of which is based on the right of self-defense. But there are many components to the individual training, including an understanding of how a merchant ship operates and its security systems, the role of ship's master, and many more things like that. And then there is the training that ought to be given by the contracting private security company, because a lot of the things that, a lot of the settings of the actual task being undertaken starts with the contract that's agreed between the company and the client, and which flag is being flown by the ship they're working with, and how they're operating, and what the client wants from the security company that is supporting them. So the whole the whole section of understanding and training that needs to be got across the team, and indeed the shore base and the headquarters staff running the business, so they understand precisely what is involved for the particular task being undertaken at the time. The third grouping that I wasn't particularly going to talk about, but it's been mentioned earlier, and I think it's very relevant to the shipping world as well, is the training that clients need. At the moment, most of our clients base their training on old requirements linked to the ISPS code, which is mainly to do with security into ports and entering to ports. So they have training as company security officers, ship security officers, but we found in the security companies ourselves that those qualifications don't cover what is now involved in undertaking security at sea, and the headquarters staff of the shipping companies could do with more training to understand more clearly what the security companies are doing on board their ships, and that's something that is starting to be addressed. But looking at the, I just put a few bullets here. I'm not going to go into detail because I think it'll be better for us to get on to the discussion of the scenario. But the areas of training that I would like to just highlight, the legal context, as I've said already, the overall context from UNCLOS and downwards, and then the legal context as agreed by the contract between the shipping company or ship owner and the private security company. There's, in that instance, and on the various codes and conventions that exist, there's been a matrix prepared within the SCEG to help companies understand how all those codes and conventions apply to their particular task at the time. Next bullet, I put knowledge of the maritime environment. By this I mean the whole issue of what a merchant ship is about, its layout, the communications methods, the role of the different members of the crew, the ship security systems, all these aspects and the operating environment and the operational threat I put in that side as well. Relationship with the ship's master is really important, and I think this doesn't quite fit with any land setting that I can think of. The leader of the security team on board, he is in charge of the other armed guards in the ship, but the ship's master has got the ultimate responsibility for everything that goes on board the ship, his ship, the safety of the ship, safety of the crew. This has created an interesting dynamic as to the relationship as to who, if there is a need to use force, lethal force, who takes the lead responsibility. And it's been looked at in great detail in the something called GuardCon, the contract for using guards at sea. But all the way through, the team leader's got to have a very, very good relationship with the master and recognize that ultimately the master's got full responsibility, but he wishes, because the master isn't the expert in the use of armed force, he will give the actual, he will delegate to the team leader at the appropriate time those responsibilities, but all the way through he's got the right to stop that action if it needs be. Overlaid on top of that, of course, is the individual's right for self-defense, that he can take the action in terms of self-defense if he deems it appropriate. So it's quite a complex mix in that area. I talked about rules of force in that regard, but the individual's got to understand all the generic elements of the use of the rules of force and the whole concept of a graduated response, and then the private security company has got to make sure the team understands the specific rules of use of force that are agreed between the clients and the company according to that flag state's law. Firearms and medical are clear areas where they've got to be properly trained. Incident management and reporting. And then finally, human rights, which Rebecca has covered in considerable detail and needs to be covered in the training for the teams to go to onboard ships. So that's the end of my coverage of maritime issues. It's a complex legal environment. It's quite different from the land domain. The company and the team on board need to understand exactly where they're operating and what they're entitled to do, have a good understanding of the master and the team leader, and need to be well trained in that space. Thank you.
Thank you, James. That was very interesting. And before we move on to the scenario, I am going to completely abuse the role of moderator. And at the beginning, Rebecca discussed the work that we do at the Fund for Peace in Cameroon. And part of the reason why I wanted to leave a quick explanation of what that actually is to the very end is because I thought it would be a good bringing together of everything that our panelists have discussed this morning, or this afternoon, depending on your time zone. As some of you are probably aware, the Fund for Peace is very active on another security and human rights initiative, and that's the Voluntary Principles on Security and Human Rights. Fund for Peace has a very long and storied history with the initiative, and we're currently steering committee and board members of the initiative. But not only are we active on the policy side, we're also active on the implementation side. And for those of you who are not familiar, the Voluntary Principles is a framework for oil and mining companies on risk assessments their management of private security and by extension proprietary security forces, and also their relations with public security forces, because of course it's recognized that many of the security and human rights problems that affect oil and mining companies often have to do with public security. However, private security is definitely a large piece of that as well. One of the projects that we've been involved with has been in Cameroon to provide human rights training to the military forces there that are charged with protecting the oil fields. In Cameroon, as in many countries, oil fields are seen as a national asset, and by being a national asset, it is mandated that they be protected by the military. And I think that this really draws on the experiences of others who have spoken this morning, in that human rights training and the effectiveness of it really depends on the approach that you take and the type of training that it actually is. In designing the training program, we actually had a very telling experience internally within the Fund for Peace. One of my colleagues previously was in the U.S. military serving in Afghanistan. He was not working on these particular programs, but because we were going to be training the military, we brought him in to get his 2 cents worth. And as soon as we mentioned human rights, his expression just glazed over. And he said to us, you know, human rights is not really my thing. But when we actually started to discuss what human rights actually meant practically, his response was, "Oh, well, we did that all the time. That was what all of our operations were based on: respecting the community, I guess what you would call a military version of social license to operate, whatever that might be." But it really reinforced to us that it's very easy to get caught up in the dogma of human rights training, and human rights training can be effective even if you don't necessarily frame it as human rights. At the end of the day, if it looks like a duck and it quacks like a duck, it's probably still going to be a duck. And that was really the approach that we took with Cameroon. Up until that time, the human rights training that had been provided to this particular battalion was, I kid you not, it was a small pamphlet that was half first aid manual and half human rights training manual. And by human rights training manual, I'm really giving it far too much credit. It was a reprint of the Universal Declaration of Human Rights. Apparently, the intent was that the soldiers would learn human rights by osmosis by reading this manual while on post. And surprisingly, I don't really think that that was particularly effective. So the way in which we went about doing the training program was to do extensive scoping to get a real sense for the kind of human rights challenges that these soldiers would face in their day-to-day operations and also in their relations with the community. And as part of this scoping, we determined that what was very important to this particular battalion was, first of all, honor. They really did see themselves as the elite forces in Cameroon, and so honor was very important to them. And respect was also a key component of it. And we really structured the training around these things. Rather than lecturing to the soldiers on what all their human rights obligations are, and after all, no one really likes to be lectured to on what they shouldn't be doing, we approached it more from the point of view of how they would retain their reputation as respected forces and how they could keep the honor of the battalion. And that was really what we based the entire training on. We also were very careful to not frame it as human rights training, which, again, I think that depending on your constituency, depending on your audience, can cause that glazing over of, oh, it's one of those tree-hugging granola things. But rather, we framed it within the rubric of human security. And we also incentivized it. We made it clear to the soldiers the benefits of respecting human rights. rather than all the nasty sanctions that could be imposed upon them or why they'd necessarily be bad people for abusing human rights, we made the case as to why it's good practice PIM, in that if you respect the community, if you respect their human rights, they are much less likely to cause security problems for you, and thus your job becomes a lot more effective. You're able to operate a lot more smoothly, and at the end of the day, if you're able to operate in a much more permissive environment, your own security is going to be a lot more guaranteed. And this is also a similar practice that we use when we're dealing with human rights training for oil and mining companies. For anyone who's dealt with oil and mining companies, you can often encounter mine managers, for example, who know nothing other than mining. That has been their entire life. And so when you come to them and try to impose human rights training, they also get a little grumpy and glaze over. But as soon as you make the case to them that if they do not respect the community, if they do not respect the rights of the community, that they're likely to suffer from roadblocks or other problems that can halt production, as soon as you make the business case to them, halting production is a risk, that's when they start to listen. So it's all about incentivizing the training and really hitting the sweet spot of what's going to count. One other thing that we noticed in our training of the soldiers was it's not just about the training itself. It's about providing the forum. When we first rolled out the training to the soldiers in that first workshop, there was going to be half an hour of delivering the training that they themselves would internalize within the battalion. It then turned into a 2-hour debate among the soldiers about whether they had handled certain situations appropriately. What we discovered was that they had just never had that opportunity before to really discuss these issues in an open forum, and I think that that was really telling as well. I think that I'm probably really hitting up against time, so I hope that that gives you kind of an idea as to how a human rights NGO like ourselves is able to provide a practical training on the ground, really basing so much on the approach, the type of training, and really trying to hit the sweet spot of what's going to make people listen and how people are going to see it as important to their lives and to their operations. I'm going to move on now to the scenario piece, and for those of you who are hanging out for questions, I promise they are going to come. However, because we're running a little bit behind time, we're going to put them at the end of the session. So we're going to move straight into the scenario, and it's going to be run by Colonel Chris Mayer, who's the Director for Contractor Standards and Compliance in the Office of the Deputy Assistant Secretary of Defense for Program Support. His primary responsibility is to develop policy and manage the department-level oversight for private security contractors, PSCs, supporting U.S. contingency operations. And his duties include acting as U.S. government technical representative in the development of industry standards for PSCs and the U.S. government technical advisor for the International Code of Conduct for private security providers. He has a very long and storied history in the U.S. military, including operating on UN missions. And as a armored cavalry officer, I didn't know this before, but he is qualified as a search and rescue pilot. And I am going to now hand it over to Chris, who's going to run the scenario. And you should all have the map on the screen. And I'm sure, Chris, that that map has absolutely no resemblance at all to South Sudan upside down. Is that correct?
Or several other places. Now, unfortunately, we don't have any time to discuss the scenario, but the scenario was all sent to you, and I encourage you to please look at it and to please comment during the week, send information back to us. Remember that the goal here for this session, between now and the beginning of the next session, is to identify what training elements we need to address. And that not only includes the ideas that you've gotten here from listening to Cameroon about other places, but also the scenario that's in front of you, and this matrix that was also sent to you. But it's not just the idea of what subjects need to be taught, and then of course we're going to match that to who that we discussed last week. but it's what are the specific learning outcomes. I think that most of the presenters today hit on those points. It's one thing to say that we need to have human rights training. Well, what does that mean? What is it that we actually need to know about human rights, and who needs to know it? Rules for the use of force was mentioned. International humanitarian law was mentioned. You know, there's a huge body of information about international humanitarian law. What is it that we want the PSCs to know? What is it that we want the people who work around them to know, and the people that hire them, and the people who are protected by them? So if you could look at those matrices, look in the context of the scenario that I won't go over with right now because I want to have at least a few minutes for questions and answers, and then get back to us, send it in, and we'll be able to summarize that. As a matter of fact, we'll even keep the discussion going during the week. So with that, I will hand it back over.
Okay, thanks, Chris. I'm going to check to see if there are any. Yeah, sorry, JJ. I was just going to check real quick to see if there's any hands raised at this point. I don't. Okay, Lynn, I see there's a hand by your name. I'm not sure if you still have a question, but we're going to go ahead and unmute you if you want to go ahead. Okay. Lynn, are you there?
Rebecca, hi. Thanks. No, I hadn't posed a question, but since I have the floor, could I pose one?
Most certainly.
Going back to the remarks that were made by Phil Drew and by Ian Ralby, and in your great presentation, the inference I would draw is that if you're training your operatives in the basis of human rights, even if your situation changes and it becomes a situation of international armed conflict, your personnel are going to be more equipped than the other way around. I mean, I take Ian's point that your situation can change very rapidly, but assuming that people really understand what it is that they're doing, what the impact on the community is, the training in human rights should surely stand them in good stead right the way through. And just picking up on the point that J.J. Messner made, when I was ambassador to Chile and used to lecture to the Chilean military, you couldn't lecture to them on human rights back in the late 90s. I used to use LOAC as a way in and get their attention in that way. Thanks.
Okay, thank you, Glenn. I'm checking to see if there's any other hands raised. I don't see at this moment. I'm going to open it up also to Chris and our panelists to make any comments if you'd like, address perhaps some of the things mentioned in the other presentation. Okay, so just feel free to speak as you'd like.
The important part.
This is Ian Ralby. I just wanted to. Oh, sorry.
I was just going to say that in going on with what Glenn said, you know, there are differences of law and differences of legal situation. And the example I think Ian brought up too was Libya, is that you had PSCs who were there guarding oil fields under conditions of human rights law and national law of Libya. And then suddenly they wound up into a law of armed conflict environment and did not respond well in many cases, moved right into DPH issues. And so therefore I think that it's there are common elements that should be able to be put together into standardized training for everybody, which would be added to if you're actually deploying into conditions of armed conflict.
Yeah, I just wanted
Ian,
to
do you want to jump in there? And I also have a question then from Mark Knight.
Yeah, I just wanted to just echo what Chris said, but also add that even if you are aware of the human rights standards, I think most people recognize that things change as soon as there's a conflict, and unless you're actually specifically trained on how to respond to that, you know, you're running the risk of having what Chris just explained happen.
Okay, so a quick intervention by JJ. Go ahead, and then we're going to unmute Mark Knight so Mark can pose his question. Go ahead, JJ.
Yeah, I just wanted to reiterate the point. I think it was a good point on Chile that Glenn made there. That you know, talking about human rights doesn't always require to use the words human rights. When we at the Fund for Peace started our national level implementation of the voluntary principles in Indonesia some years ago, human rights was a touchy subject in Indonesia, and so our route in was actually talking about health. And so our human rights initiative there was actually called the Health and Business Roundtable, and that's how we actually managed to segue into human rights. So I just wanted to reiterate that point.
I'm just going to actually steal 10 seconds to say something to that. I think you're absolutely right. As an initial in, it may not be beneficial to speak directly of human rights, and I know from other friends who are dealing with how companies are operating in China, trying to set standards there that involve the Chinese government in that standard setting process. They also avoid the word human rights like the plague. I'm hoping, though, over time that there will be some kind of ratcheting up that goes on, because I think that, you know, beyond being concepts, human rights, in order to be upheld, are also connected to quite a significant implementation framework at the UN level, also at regional levels, at national levels through, you know, national human rights institutions. And I think at some point, I hope people get to a place where they understand that those principles are actually codified somewhere and can be enforced. That's a very important aspect of that. And with that, I'm going to stop talking. I'm going to hand it over to Mark Knight. Mohammed, can you unmute Mark?
Am I on? I think I am.
Go ahead, Mark.
Okay, I just have two comments and a question for Philip Drew, if that's okay. The first one about approaching the companies with the human rights terminology. And instead of trying to package it in another way, which is a good method to get there, we also directly go to the companies and explain how human rights relate to their services in terms of everyone has the right to life, liberty and security of person, which can be translated into their services, and also everyone has the right to own property and not have their property arbitrarily removed. Two core services that the industry provides. And when they start to see it like that, they start to understand themselves in the human rights arena, and that helps a lot. In terms of getting traction, I refer back to the Montreux document where it talks and defines superior criminal responsibility, which is also something in terms of not only training the tactical level operators, but starting to move into the managerial levels. They're my two comments. The question I had for Philip Drew was whether he could comment on the direct participation in hostilities and the ICRC interpretation, the three consecutive elements of threshold of harm, direct causation, and belligerent nexus. Thank you.
Phil, are you unmuted? Can you speak?
Yes, I'm not quite sure that I understand that question. That is a huge issue. Is there a context in which you would like to place it?
Is that back to me?
Yeah, Mark, you're still unmuted. Go ahead.
Okay.
Yeah.
No, it's. I mean, we touched on it at the beginning, and in terms of the IHL knowledge that is required by PSC operatives, obviously direct participation in hostilities, as he says, is still a contested and evolving concept, but there is a interpretive guidance by the ICRC which outlines it in those three accumulative requirements of, you know, it is direct participation when these concepts are accumulatively passed by an individual, which is a threshold of harm, direct causation, and belligerent nexus. Now, translating that into examples for training is another thing. I was just opening up the debate and taking it slightly back to IHL and direct participation. So, any comment on that, really?
Okay. I understand much better now what you're getting at. The problem being with the 3 steps is that the model as set out in the in Nils Meltzer's document, while I agree with it, there are countries that will interpret it differently. And the whole concept is, when do you hit that threshold? What does it take? And then what is, or how long does one remain as DPH after they've done that bad thing that has made them lose their protection?
it is the understanding, and this comes into scenario specific training and task specific training, and understanding the environment into which one is going and the various different players and what their various interpretations may be. Unfortunately, governments have been loath to step forward and actually give their understanding of where those thresholds are, and instead have used, in many cases, academics to spell that out for them. But trying to get a concept as to where a certain country is going to push that button on you saying you are now DPH is critically important to the PSC, because they may end up in a lot of trouble in a given situation if they're against one country, whereas with another country they wouldn't. You know, again, this is going to be task specific and very much dependent upon where they are and who the players are. Does that help?
Is Mark still unmuted?
Rebecca, I know we're over time, but I'd like to make one comment on that.
Yeah, sure. I was actually, if it's okay, if it's a quick question, I had one more question, Chris, if we could field that, and then and you can make a comment, we can close.
Yep.
The other question is from Andrew Taunton. Mohammed's going to unmute Andrew. Andrew, if you would mind asking your question perhaps in a briefer fashion than you had initially intended, and then we'll let Chris comment and close up. Go ahead, Andrew.
Thank you. I was really just going to make a couple of comments. First of all, excellent session. I've come to this a little later than some of you, I'm sure, but I'm looking for some very practical input to a situation we face at the moment, and the speakers have given a lot of advice, which I think I can put to good use. I would like to say thank you. A couple of comments, simply. GMs in foreign countries, especially foreign GMs, run a serious risk of falling into legal problems. The thought about the master of the ship being in a condition where he has to pass over responsibility is, I think, quite analogous to a land-based situation. I think one particular GM I have in mind would agree very much that he has a huge responsibility of knowing when to let go and when to hold on. I just wanted to make that comment. I think there is quite an analogy there, but may not be in the same legal sense. Thank you very much for the speakers. That was really my comment.
Thank you. Thanks, Andrew. Chris, I'm going to hand it to you.
Okay, real quick. What Phil said is very appropriate to PSCs, and that's what he used the term PSCs. But remember that the Montreux document and our sessions here also do touch upon private military companies. And private military companies are much more likely to get involved in DPH than PSCs. And so we need to be able to be aware that they understand, too, what their liabilities and risks are should they get involved in direct participation hostilities. We're not talking about the executive outcomes, but we are talking about like the MPRIs of the world or DynCorp in certain situations. Very importantly, that the United States government really does put out restrictions on the use of direct participation hostilities by PSCs, and we're very clear to make it what those boundaries are. And we go back to the ICRC direct guidance on direct participation hostilities, and that is we need to focus and put limits on it so that the use of force is only self-defense, defense of others against unlawful attack, and we need to be very clear then in identifying what is a lawful and unlawful attack. Thank you.
Okay, thanks, Chris. And
Rebecca, can I make one quick comment?
Sure, Ian, go ahead.
10 seconds. Just I think that very example highlights one of the things that I didn't really mention, which is that unfortunately, whether it's internationally or within any national context, a lot of the issues that arise are not 100% black and white. And I mentioned discernment and discretion quite a few times, but this is one of those areas where you can't know the answer. You can only know the context as well as possible. And I think one of the things to emphasize in training private security companies, their personnel and everyone else involved in the industry, accreditation bodies, certification bodies, etc., is that things aren't black and white. Things are often life or death. It's really difficult to judge, and the best thing we can do is have as much education as possible so that people are aware of what the constraints may be. But fall short of actually saying what they specifically are.
I think that's a really important point to make, Ian. Thank you. Okay, so thank you, Ian, the other presenters. Thank all of you who participated today. There were a couple additional kind of chat comments that were made, which we can't get to now. Those of you who are new to the webinars, I will be placing you on an email burst that allows you to directly communicate with each other, and I really, really encourage you to raise points that you didn't have a chance to raise today and to really start a discussion there. Please register for next week's webinar, which is on the providers and methods of delivering training. So I think we're getting to some of the how do you go about delivering training. And please tell your interested colleagues to join us. Thanks so much. Have a good day, everybody. Bye-bye.